right here. In the hot seat this morning, we will be talking Justice Thursday conversations. And our conversation this morning is around another tribunal that is representing the needs of very many people. The Honorable Ndegwa Wahome is here as the member of the Business Premises Rent Tribunal. Good morning, Honorable Ndegwa.
Good morning.
How are you?
I'm very well.
Karibu sana.
Happy to be here.
Well, great to have you here.
Yes.
We continue having conversations around access to justice, widening that net, broadening perspectives, and also deepening opportunities for Kenyans to have access to justice. Of course, we know what the Chief Justice has done in terms of trying to make sure that that becomes more apparent to people. So it's good to have this conversation with you this morning. We'll be looking at the role of business premises, this tribunal in the expansion or enhancing of access to justice. So we're glad that you're here with us this morning.
Yes.
As we welcome you to the Situation Room, CT goes to a different African country every week. He comes back with a basket full of proverbs. He shares one proverb with us every day.
Yes.
And your job, if you will accept it, is to give us your interpretation of that proverb. You do this all the time anyway.
Okay.
So let's hear what it is.
Bring it on.
Yes, we are. Thank you very much. We are in the Republic of Malawi.
Yeah.
Buffaloes are held by ropes, man by his words.
Yeah, I think your word is your board as a man, and you are treated and seen through the prisms of what you talk. So I think that is the very manifestation of your being as a person.
Very well said.
Indeed.
Very, very well put.
Absolutely.
Yes.
So, getting that interpretation is great. And we've heard that for every issue that you might have, it's possible that there is a tribunal that will be able to sort it out for you.
Yes.
And when we look at alternative justice resolution systems, we also then say it's not necessary for everybody to cram the courts, and to wait for long periods of time for matters to be heard within the court system. And because of that, then tribunals then were established to ensure that certain matters within certain industry or sector could then be handled. So we've been looking through a couple of those on Justice Thursdays, and today we look at another one. We want to hear from you, Honorable Ndegwa. We're looking at the Business Premises Rent Tribunal. First of all, give us a description of what this tribunal does and what its activities entail.
Yeah, thank you very much for having me this morning. For the Business Premises Rent Tribunal, I would first want to say that it is recognized under the Constitution. Mm-hmm. Article 169, 1D of the Constitution recognizes that there shall be tribunals which should be in the hierarchy of courts within our judiciary. And pursuant to that, although the Act came before the Constitution, but now the Constitution has captured the need and the existence of the tribunals. We have Chapter 301 of the Laws of Kenya. That is the landlord and tenant, in bracket, shops, hotels, and catering establishments, in bracket, Act, Cap 301 of the Laws of Kenya. And it is the law that governs what we call controlled tenancies. There are so many tenancies, but those under the Business Premises Rent Tribunal are controlled tenancies. There are other tenancies and leases and licenses that do not fall within our jurisdiction, and they fall within other tribunals' jurisdictions or the general jurisdiction of the civil and commercial courts. So for us to have jurisdiction over a matter, there must be a landlord and a tenant relationship that is controlled. Being controlled, one is that it is not in writing, it is not written. And this was to take care of our people at independence, where they came into business, and most of them had not had the advantage of education, and therefore they were entering into very informal agreements of renting. You hear of Africanization of business within Nairobi, and most of them would get into them without anything written. Therefore, that kind of a narrow arrangement, informal arrangement, became a controlled tenancy, which would be governed by Cap 301. And Cap 301 is a specially made piece of registration to take care of interest of those who might not be able to be loud enough to speak for themselves. And it is for a class of protected tenants, and it calls for complete compliance. Number two is that if that arrangement or agreement between a landlord and a tenant does not exceed 5 years, then that is a controlled tenancy. And the third issue is that if it is for beyond 5 years, it must have a break clause, or what we call a drop clause. That agreement can be cancelled not because of breach of any covenant, but because parties agreed that they will exercise freedom to call off that arrangement at any time within the period, if it is for 20 years or such. So those are the three parameters that qualify an arrangement between a landlord and a tenant to be a controlled tenancy, and therefore to be governed under the Cap 301 of the laws of Kenya. Yes.
So, who takes up these tenancies essentially, or is it any business, any rent, anybody who essentially is taking up these tenancies?
Anybody. When we talk of a shop, even a law firm is considered a shop.
Okay.
A hospital is considered a shop.
Okay.
All of those businesses that offer goods and services.
Yes.
They are shops.
Okay.
And therefore, anyone taking a space within that definition of a shop, and I've said that the definition is very wide.
Yes.
Then you are within the parameters of control under Cap 301.
Okay.
Yes.
Now, under what circumstances possibly would then I or anyone within this controlled tenancies come before the tribunal with an issue?
Mainly is because one, and the main issues that come to the tribunal is there are two set of circumstances that bring people to the tribunal. One is where there is termination. I am in an arrangement with you, and I want to terminate that arrangement, the relationship. Then I need to issue you with a notice of termination.
Yes.
When I issue you with a notice of termination, you have a room of that days to write back to me and tell me, no, I don't agree with you. And then within 60 days or 2 months, actually we make a mistake, and a landlord will issue a notice and say it is between 15th of June and the 15th of August, 60 days. But the law is very clear, it is 2 months. And under the interpretation, then 2 months is 2 calendar months. You cannot count any half of the month. So if you issue a notice on 15th of June, June does not count.
Oh, really?
It is July that counts.
And August.
And August.
So then the person would be expected to move on the 1st of September.
And that is where most of the landlords fail. They will give 60 days, but those 60 days are not 2 calendar months. So that termination notice will be found to be defective, and it will be dismissed. So that is one of the areas where the tenant will come to court now and say, I've been given a notice. This notice does not meet the prerequisites of the law because it does not give me 2 calendar months. Number 2, it does not give me the grounds of termination. Under Section 7 of the Act, it is very clear the grounds of termination. 1 is that you have been in rent arrears for more than 2 months. That is a ground for termination. Number 2, that you need, as the landlord, to use that premises for more than 1 year for your own businesses. And you must show clearly your intention to run a business for more than 1 year. You must show your plan, your financial capacity to be able to do that. The third main ground is that you want to demolish. Like now you go to Kirinyaga Road, you find those are the old premises, you want to do a high rise, and therefore you need to demolish and reconstruct. That is another ground of termination. And then obviously if there is a breach of covenant.
However, with the grounds of termination, there must be the 2-month notice.
The 2-month notice is mandatory. And that one cannot be compromised. There is a case we call the Rokas Krasekas case of Frederick Muringe Mutua, trading as Kitui uniform versus Kitui Teachers Housing Circle. where the court actually set the law. That this is the law and it must be followed. There must be complete compliance with the law. And we have been following it. If there are not 2 clear calendar months of notice, that notice is still born. Yes.
So, Bashima, right now I have an issue. You are my landlord. I enjoy security of 10 years. It has come to a point where my lease is coming to expire and I need to renew that. But I come to the landlord and the landlord says, I am not renewing with no reasons given. Is that basis enough for me to come to the tribunal because my renewal has been denied without any justification or reasons?
Yeah, you have a right to come to the tribunal to look at the circumstances of the kind of arrangement you got into, the kind of goodwill you have put into the business, the kind of investment you have put into the business with the authority of the landlord. And if the tribunal finds that actually there was those expectations that have not been met by this notice, the tribunal will obviously weigh in. One, it has powers to order for compensation for the losses that you might undergo because of the goodwill that you have invested, the developments that you have done with the consent of the landlord, or it can direct that you be given a particular period of time within which to try to recoup back your profits from your investment in the business. Yes.
Okay. Now, you're in arrears for 2 months.
Yes.
Under the law, you then stand at grounds for possible, termination of your lease agreement.
Yes.
Now, even after you owe 2 months, so when the landlord comes and says, I have to terminate this because you're in arrears, do they still need to give you the 2 months for you to find a place, or can that be an immediate termination and say go tomorrow?
Have to give
you still have to give
bottom line is the 2 months, but then the landlord is given a leeway.
Okay.
If you feel that termination, the notice will take long, in the meantime, you are able to refer distress and recover your rent. As you pursue the termination, you have already recovered your rent. And you don't require the license or permission of the tribunal to go and refer distress for rent. What you need only to confirm is that there are rents in arrears. Then you go and refer distress, recover your rents as you pursue the termination because of the rents that had fallen in arrears for at least 2 months.
Okay.
Yes.
I want you to explain a little bit because I didn't quite get it.
Yes.
What sort of businesses or tenancies fall under the controlled bracket?
The tenancies are those that are not written. All the tenancies that are not written, multi-million, multi-billion, that they are not written. But there is landlord tenant relationship where there is profit changing hands, there is occupation of space, and there is payment of profit. Then that is a controlled tenancy if it is not in writing. Again, it is a controlled tenancy if it is in writing and it does not exceed 5 years.
Meaning if the contract does not exceed 1 year. I mean 5 years.
5 years, yes.
So if somebody has a tenancy and it is only for 1 year,
Yes.
it can still be considered.
It is controlled. For 1 year to 5 years, if it does not exceed 5 years, it is a controlled tenancy. If it exceeds 5 years, but it has a break clause, it says it is a tenancy for 10 years, but then I have a right to give a notice of 3 years or 3 months to terminate, or 1 month to terminate, then it is still a controlled tenancy. Unless it is for 10 years, but it can only be terminated because of breach of covenant. That one is not controlled.
Okay.
Yes.
And because I think that when you said what you said, especially about the 2 months, I think all of us opened our mouths in shock because the number of people who've been asked to leave by Friday is unbelievable, without realizing that your rights actually are that you can have 2 months in terms of a hold. For people to even know that they live or they operate within controlled tenancies also is, people perish for lack of knowledge. That's just very clear.
Yeah.
But now, do these issues then have anything like a statute of limitations upon them? Because I would think of the number of people who've gone through severe loss and damage when they've been asked to move tomorrow and they've had to do that. Does it have statute of limitations whereby somebody can come back to the tribunal after the fact, even if it's been for some time, and say, I went through this issue?
Actually, it is a very contentious area because the wrong, and that has been the interpretation, that you cannot go to the tribunal if you have already been evicted.
Oh.
The tribunal's jurisdiction is ousted. That there must be a tenant and landlord relationship for the tribunal to have jurisdiction. So if you have been thrown out, then that relationship is terminated and the tribunal does not have jurisdiction.
Honorable Wahome, let me ask.
Yes.
If someone has been thrown out and the stipulated required periods are not adhered to, simply because the landlord doesn't want you there and they're evicted, meaning they've brought people who have taken out your things and then they've locked the door with a padlock, such a person cannot come to the tribunal.
Actually, I was coming to that. That is the actual position. There is a case we call arbitrary, East African case of 1972. It established that, and many other decisions of the Court of Appeal and the High Court. But what we are doing today, and actually it is in consonance with the law, is that under the definition of who is a tenant, it says the person who is entitled to the tenancy, whether or not in possession. And actually, in my court, and in the other courts within the tribunal, we are 8 of us, we are enforcing that. That whether you are evicted or not, the landlord is purporting to have terminated the landlord and tenant relationship. But under the definition of who is a tenant, it is the person entitled to those premises, whether or not in possession, and we are actually reinstating tenants into premises from which they have been ousted irregularly. Without following the due protocols of the law.
Okay.
Yes.
And how long would they then be able to live in any kind of symbiotic relationship? If you've come to the tribunal, you've been reinstated, can the landlord then come back and say, well, now, since they've asked me to give you 2 months, I'm giving you 2 months, and you find yourself on the out again? Wouldn't that be a possibility?
Yeah, it is a possibility. But again, there are issues that the landlord is required to prove. Like the tenancy, you have to show that clearly there has been rent arrears in 2 months. Number 2, you have given the notice, the tenant has charged, now it comes to the hearing of the matter. The landlord has to come and show that actually there was rent in arrears for more than 2 months, if that was the ground, and there will be a full hearing and a judgment will be rendered to that effect. Number 2 is if the landlord says that he wants to occupy that premises, he must clearly define what business he wants to put up in those premises, and that he has the financial muscle to be able to run that particular business. And he has a plan for that business, that the intention is very clear. Finally, if you say that you want to demolish and rebuild, you must bring approvals from the government agencies concerned with construction. You must show resources to do that and approve the plans and everything. So it is not as easy as that. We try as much as possible that within 6 months, that is 180 days, that all the matters are disposed of. In case of matters that have come under certificate of urgency, within 60 days. But at the end of the day, it is a normal process of the hearing the matters, but the rules are a bit relaxed to ensure that there is easy access to justice. Yes.
Honorable Negwa, there is a matter that Kenyans pretty much continue to suffer every other time, which is the rampant increase of rent without any justification, where today perhaps they want me out, but instead of telling me rightfully so, is they increase the rent just so I get out. Is that a matter that you frequently see in your court?
Yes, we have seen it. Actually, it is one of the main issues. And under the Act is that in alteration of a term of the tenancy, must be followed by a notice. Also a 2-month notice. The landlord must clearly state to the tenant that I want to increase rent because of A, B, and C. Then the tenant will slide to the landlord and tell him, no, I don't believe with the market forces. I feel that the rent I'm paying is the correct rent. If the landlord is not satisfied, the tenant will come to court and say that the landlord should be stopped from increasing this rent. And if the landlord insists that they want to proceed, then I will ask the landlord to prepare their case, compliance with Order 11 of the Civil Procedure Rules, file your valuation report, file your witness statements, the same case with the tenant. You come, we hear you, and with the aid of the valuers, who are the experts in that area, we shall be able to assess the market rates within the area and then give a declaration or a judgment on the rent payable.
Okay.
Otherwise, we have full discretion, which must be exercised judiciously on allocation of rent for particular spaces. So
on the same, does it mean that the court in such matters is able to give an order on how much rent is to be paid at the premises? Yes,
that is one of our jurisdictions that we are able to say that this particular space will pay this much rent, and also on service charge. We have the discretion also to allocate the amount of service charge to be paid in premises where the tenants are many.
Wow.
So that we are able to share the service charge among the tenants. This piece of registration is a small one, but very rich. And it is only that many of us,
we don't know.
In business, do not know about.
So I shudder to think about the numbers of people who essentially have been abused over the years because they are unaware of this information. One other big issue is that of deposits. That you're asked to pay, in some cases, as high as a 3-month deposit plus 1 month's rent. So you pay 3 months deposit, 1 month's rent. Now, upon you wanting to exit the premises, you need your deposit back because, I mean, biding any kind of damage or painting or whatever, then they can deduct that. But to get this amount back for a lot of tenants has been a tooth-pulling exercise. Does this come to the tribunal as well, and how is that handled?
Yeah, they come, and the tribunal has sweeping powers under Section 12(1), where that in a relationship between a tenant and a landlord, the tribunal has powers to make on orders to ensure that justice is done within the circumstances of that particular matter. And the justice of the circumstance where you have paid a deposit is that you be refunded your money, and we easily make those orders.
Honorable, and here's a question where there is the aspect of I've paid my deposit. There are those who we need to get some money back for painting and whatever, but there is the other side where I came to a bare space, I improved on the same, and I'm living it better than I found it. In such situations, how do you handle it? Because as a tenant, I'd say, I need to be compensated for this. Is that an issue that would appear in court?
It would be an issue, but then even if there is no any written agreement, you will find that there are inferences to the schedule, to the act, that any improvement, because there was, I believe there must have been a lot of mischief that the law tried to cure, is that somebody would come in and say you have used millions of money and done this much. So what the law says now, and what the law allows us to do, is only to compensate for goodwill and improvements where the landlord had given consent in writing. So it becomes very easy for us. If there is consent that you are doing this improvement and there is proof of those improvements, we are going to compensate. If there is goodwill and it was agreed it would be paid because it will be easily assessed through the person who is coming in. It becomes very easy. But the law refused to leave it blanket for conjuncture, where it is not agreed on between the two parties. So the bottom line is that the improvements, the goodwill will only be paid where the landlord has consented in writing.
Okay, just one question. We're going to take a break, but there are very many questions coming in, and I think maybe you can handle those one by one as we come in from the break.
Okay.
But one thing is that you did mention that this tribunal sits on the basis of an ongoing relationship between tenants and landlord.
Yes.
So let's look at the event whereby a deposit is refused, but you've moved out anyway because that pressure is still there. There's a pressure to move, and there's also the you wanting to get your deposit back. Would the tribunal still come in? I have moved. I have left the landlord with my deposit. Can I come to the tribunal and say, I've left, I've moved indeed, but they still have held on to my deposit if the relationship between us has already ceased to exist by virtue of my exit?
No.
Okay.
Once the tenant is not insisting on the tenancy, that the court is not required to define whether the tenancy is still in existence, and the tenant has moved out and only wants the deposit back, then that way the landlord and the tenant relationship is not there.
Okay.
Remember the latest High Court decision where the High Court said that the tenant should have moved to the small claims court to demand back your compensation. So actually, once the relationship is terminated, then it is the province of the civil or commercial courts for recovery of the deposit.
Wow. Okay, let's take a break because it's very clear that there are lots of issues that folks wish that they would have brought to the tribunal when they were dealing with them because they have become quite a thing. Our Justice Thursday conversation today is wrapped around enhancing access to justice via way of the business premises rent tribunal, and the Honorable Ndegwa Wahome is a member of this tribunal, is helping us out through some of these things and many things that you didn't know, isn't it? We'll come back and we'll start to tackle those one by one right after this.
Chapter 3.1 of the Laws of Kenya, and I've said it is as one of the wrongest titles, the Landlord and Tenant Shops, Hotels and Catering Establishments Act, Cap 301, and we first ensure that to be able to handle the matter, there must be a controlled tenancy.
Okay.
And then there are two ways of filing a suit before us. One is where there is a landlord who wants to alter the terms of the tenancy by either terminating the tenancy, increasing the rent, increasing the service charge, in any way wanting to alter the terms of the tenancy to the adversity of the tenant. There must be that notice of 2 months to be done. And if the tenant is not satisfied, then what happens is that the tenant is at liberty under Section 6 of the Act to file a reference with us. That reference, once it is received at the tribunal, then the process of the landlord to alter the terms of the tenancy is stopped with immediate effect. Immediately, the reference is filed with us. The other category is where the landlord has disconnected water, has disconnected power, is not collecting garbage, is harassing the tenant. Then under Section 12, the other one was 6.
Yes.
Under Section 12, we file a complaint with the tribunal, and the tribunal is able to handle that complaint. Immediately it is filed, then the tenant, whoever has filed, or the landlord, is directed to serve the other party. And then they appear before the judicial officer for case management, where it is agreed on how the issues at hand will be deliberated on, whether it is by either oral submissions, whether by written submissions, or by viva voce evidence, where witnesses will require to be called, and depending on the way the case will be heard, then a ruling or a judgment will be rendered in the matter.
On the matter?
Yes.
Okay. We look at a lot of these cases and how they affect tenants. But are there cases that can be brought to you then by landlords in terms of things that may have happened to their detriment as well?
Yes, many of them. Where like rent is not being paid, the tenant is breaching the covenants by doing businesses that were not the agreed businesses. They were supposed to put a clothing shop, And then he is selling wines and spirits. And then he is demolishing some walls to create more space. He is making additional structures, erecting additional structures within the area. So those are complaints that the landlord will bring many times, and especially in Nairobi, where in the estates you find a shop was initially even a residence, and then it is extended to be a place of leisure, and there are erections and many things done without the consent of the landlord. So you will find that landlords are coming to us almost in equal numbers, like tenants. Landlords mainly with complaints, but tenants with differences, because the terms of their tenancies, the landlords want to alter them without following the due process of the law.
One of the things that is prevalent in many, one sees it in government when the days when there were many government houses, but subtenancy. Somebody is a tenant and they then bring in their own tenant.
Yes. Actually, that is another major ground of termination of tenancies by landlords, where a subtenant, where you find that a tenant, and this is an implied term under Cap 301 of the laws of Kenya, that for a tenant to sublet a subtenancy or to create a subtenancy, even without any indication within the tenancy agreement, that tenant must get consent in writing from the landlord to be able to create that subtenancy. So most of the tenancies that are terminated actually are on the ground that the tenant created a subtenancy without the consent of the landlord. So it is one of the major complaints by the landlords. Yes.
And how then is that handled?
Obviously, that is a breach of a covenant, and you will find that the court will normally go by the landlord and find that the tenant was in breach and be able to cancel both the tenancy and the subtenancy. Yes, but the due process of the again, once the subtenancy is created, the court must first investigate even the subtenancy before it can proceed to terminate both the tenancy and the subtenancy. Yeah, but it is a major complaint by landlords about the creation of illegal subtenancies within the premises.
Another issue that we see often is that obviously because of certain things, whether it's payment of rent that has not happened, that certain amenities or services then will be stopped. Whether you have a blockage of the sanitation system or that you have a switching off of the lights or water because payment has not happened. Is this something that can then come in? You know, people can claim loss and damage because of that. Is this something that can also be handled? And then what are ways in which this can then be sorted out? Is that a recourse that landlords can actually take, blocking the water, switching off the lights in order to spur on a tenant to pay?
Or locking the door.
Or locking the door, locking you out.
And locking you out.
Yeah.
Yeah.
There's one I heard that actually a German Shepherd was chained on the door so you can access it.
Or locking you in, for that matter.
Yeah. So I think those are the ways that I used to twist tenants most of the times to make them pay for the utility bills and also pay rent. But what we say is that they are not recognized by the law, and therefore they are illegal. And the landlords are exposing themselves to being condemned and slapped with the compensation fiat by the courts. So at the end of the day, if a landlord, there are any wrongdoing on the part of the tenant, they are not complying with the terms of the tenancy, and most of them are implied within the law, let them come to the tribunal with their complaint, and the tribunal is going to address them. If there are any utility bills in arrears, they will be ordered to clear them, the tenant. If there are issues that have not been addressed and are required to be addressed, either within the terms of the tenancy or the implied terms, we are going to enforce them. as the judicial officers within the tribunal. What the law frowns on is when you take the law in your hands. You might be the offended person, you end up being condemned to pay compensation.
Bonandego, do you know how many people today, even as we speak at this moment, are going through the thing that you're saying that the law prohibits them from doing? Whereby water is being switched off, houses are being closed, people go to work, come back, there's a padlock on their door, the water has been shut off, the lights have been switched off. In fact, the whole thing has been pulled out of the wall to move or to urge these people to pay. Do you know how many of those things go on every single day?
And that is why we are here. We are encouraging those who are confronted by such charges that there is reprieve. When they come to us, the justice is relaxed. They are able to access us, and we are obviously we exercise that independence. We are responsive, and we are ensuring that justice is able to be administered to everybody, even those at the lowest. Within the structure of the society. So why we are here, it's because people should understand their rights. And a right can sleep, but it cannot die. So that those rights are there. They just require and need to be enforced. And there are mechanisms to ensure that those rights are enforced. And these laws are not made in vain. These laws are made for application. And as a tribunal, we are ready to apply them, and we apply them. And we have seen results, like in the areas where you find that people are very civically very active, like in areas like Kakamega, obviously Nairobi, areas like Mombasa. You will find that these issues of very truant either landlords on the side of the landlords or the tenants, that they are actually going so low, where we could find that there were about that matters coming in one day, where doors have been removed from business premises, where roofs have been removed. That's these days it is very hard to hear about those kind of things. Where a landlord would go and just remove a whole roof, remove the windows, even demolish a whole building so that he could get rid of the tenants. It is very unlikely to hear about it today because the compensations are very harsh. When you do those kind of demolitions, those kind of evictions, you find that you are condemned to pay in terms of millions. Nobody want to get themselves into that kind of a situation.
Honorable Degba, there is the Utadu landlords. What will you do? Okay, fine. I have a matter. I've come to the tribunal. They have got a notification from the tribunal, but they go like Utadu nini. What will you do? And they even proceed to hire goons, bring auctioneers, and completely eject you from the premises. How would you respond to such kind of landlords?
What I'm saying is that the legal protocols are there. The law is never in vain, and there are no gaps in the law. Where a tenant has actually evicted or demolished like a building, that there is no way of reinstating the tenant. With evidence, we are going to ensure that the tenant is fully compensated for that. And obviously, in case of the landlords, there are ways of recovering these damages that we have awarded to the tenant. And what I'm saying is that these days, and it is very rare, when I joined the tribunal in 2023, I had so many matters coming to me where a roof has been removed, a door has been removed, a window has been removed. And at that time, you'll find that initially there was only one judicial officer within the business premises rent tribunal across the country.
Wow.
He would take 3 years to go to Kisumu. And therefore, the landlords knew, I evict this guy. When the judicial officer is coming, the man will already have been even forgotten, and the case will have died a natural death. Then, when we were coming in, there were 4 judicial officers. Today, we are at 10. Within 6 months, within 30 days, in case of applications for injunction, we have dispensed with them. So the issue of access to justice, that when a tenant is coming to you grieving, within the same day, like now the judicial officer who is addressing the issues of certificates of urgency this week, Honorable Patrick Kitur, he is able to stop landlords and tenants who are becoming truant on their tracks by issuing orders with immediate effect. In the past, he would go even for a year without your certificate of urgency being had. So this access to justice, this responsiveness by the tribunals, we are able to address the issues immediately, and therefore the landlord or the tenant, whoever does not want to follow the law, they know that within days the law will have caught up with me.
Right.
And therefore the access to justice has really cured most of these maladies.
Is there a cost to come into the tribunal?
There is cost, but very minimal.
How minimal is it? In terms of Kenyan shillings, how much is it?
Actually, it will go to as low as 550 shillings to 150 shillings. But also, in the case of recovery of rent, it is percentage of the rent you want to recover.
Okay.
So, therefore, the tribunal, the access to justice, when we talk about access to justice, is that it is minimal charges compared to the courts.
And what percentage of the rent would that be? Is there a minimum and a maximum amount, or is it a flat fee?
It is according to the rent that you are seeking for. I think it's about 4%.
4%
of the rent that you are claiming.
And it's only 4%.
4%.
Okay.
Yes. So that then you are able to be processed the documents or the decree to be able to go and recover the rent. So in general, what I would want to say, the expansion of the tribunals and the creation of tribunals in all aspects of our lives, and the easing of the rules that regulate the operations of the tribunals, they have made it easy for justice to be dispensed within the shortest time possible, so that those people who were thriving on the delay in the dispensation of justice, now this time they have nowhere to run to. You know, I will go to court, but within 2 weeks, within a month, the case will have been decided. I will not have achieved my objective.
So I guess you partly answered what my next question was going to be in that response that you've given, because then what is the time that it takes to adjudicate over these matters and get some kind of resolution once I present at the tribunal?
For applications, we are doing it. And actually, another thing I would want to say is that we are doing 99% partial hearings. So like now when I live here, I will hear matters in Nairobi, I will hear matters in Kisumu, I will hear matters in Mombasa, in Kakamega, in all our 10 stations. I will at least have one file from each of the stations, and I will dispense with them today. And the others will be adjourned for another day, and others will be reserved for rulings and judgments. We have 10 stations. And for applications, we are giving ourselves, and which is a policy position, 60 days to dispense with the applications, to dispense with the matter conclusively within 6 months. You are done with it. Like now, and in my court and in most of the courts at the tribunal, I cannot remember the matter that I have for 2023. And those are the matters where there have been appeals to the High Court or to the Environment and Land Court. Otherwise, we are dispensing within 1 year. You will find that the matters for 2024, by the close of 2025, that there is no matter pending in 2024 except those ones where there are appeals in the Environment and Land Court.
Okay.
Yes.
Would you say that Kenyans are embracing this ADR mechanism coming to the tribunal court?
Yes, I would think so. And also the judicial officers help in that area. Because when you look at the file and you find the notice was not proper, you find that it is a question of payment of rent, there is no way you can escape that. And you talk to the parties, this is a question of payment of rent. Do you have any problem if your rent is paid and it is paid on time? And you find in most of those times, the lawyers and even where the litigants are on their own, they will ask you for time. And like yesterday, I remember I recorded about 3 consents. They come very serious issues. When they came to court, the dispute was very heated. You could not think that they would find convergence. But they come after a month, they have cooled down, and they are recording a consent and agreeing to continue with the relationship for the benefit of both.
Yeah.
Yes.
Okay.
One of the things that is always a problem when it comes to accessing justice is actually understanding how you can access it. The judiciary under Justice Martha Koome has made huge strides in ensuring that justice is actually accessed by almost anybody who seeks it. Now, on matters of rent, beyond a conversation such as the one we are having, how does the judiciary make it possible for people to know the very things beyond what we're saying here? We have spoken. For instance, you have a website, the social media that the judiciary has. How do you utilize these tools to ensure that these things are passed on so that people can actually consume it, access it, and know how best they can utilize it for their uses?
Actually, like in the social media, I think we are very active. The tribunals are very active in the social media space in sensitizing people about what we are doing. The stations where we are operating, like I have said, we are operating in 10 stations. We have stationed personnel, and we have what we are calling shared services. Like now here at Kenya Re Towers, we have about 23 tribunals where we share the ICT personnel, we share the secretarial services, we share the crack services, we share all those other services to make it easy, cost effective, and therefore make even justice cheaper to the consumers. Again, we have these judiciary open days where we are pronouncing them to the public, and we had one about a month ago. The whole day we were at Kenya Re Towers. Members came, the tenants association. There is a tenants association in this Kenya for the tenants who do business. They came to us and we took them through the processes of how they should lodge their complaints, how they should address their concerns, and even how they should lobby for the tribunal bill that is in parliament so that their issues can be incorporated when the bill is enacted at last. We had the Landlords Association. They came to us, we engaged with them, and we took them through the protocols that they should follow to address their interests. I'm in charge of the Western region for the Business Premises Rent Tribunal. About 3 months ago, I was there in Shinyaru in an open day, and you go and address stakeholders on what Business Premises Rent Tribunal do, how they should approach it, and what they should expect when they approach the Business Premises Rent Tribunal.
It is laudable, it is commendable. Yes. How then do you ensure that every part of the country where you have people paying rent, beyond just the big towns, because this is knowledge that, as you say correctly, should be easy to access for every citizen of the country. Do you have a plan? Is there a process by which there is a guarantee that every part of the country will be reached in the course of whether it is 3 months, 6 months, a year?
So that is still a challenge because of the question of resources. But in the meantime is that we require to really exploit the digital space. Because today, a litigant who is ICT SWIFT or ICT literate, when you are in Northeastern, you can file your suit before the tribunal in Nairobi or before the tribunal in Meru. But the main problem is that even that literacy in the area of ICT is a problem. And I think this is an effort that should come from the government itself, not even the judiciary, to ensure that the ICT hubs that were to be created. Because if we have an ICT hub in Wajir, a resident of Wajir who has issues with the rent, with the issues of the Business Premises Rent Tribunal, would walk into that ICT hub and lodge his suit or her suit with us. So this is bigger than ourselves that requires to be looked through the prisms of the national government on how to be able to bring justice, as the Chief Justice has done and has actually allowed us facilities, to answer your question, that our offices are almost in all the courts in the country, at least 10 stations. We have Meru, we have Embu, we have Nyeri, we have Mombasa, we have Kisii, we have Kakamega, we have Nakuru, Eldoret, Kisumu. At least the Chief Justice has ensured that when we have the manpower or the human resource, that we are given a small space, that somebody walking in with rent issues, with the Business Premises Rent Tribunal's issues, then they are able to be embraced and addressed at that particular forum.
And at that place. I want you to say something really quickly as the time is actually running out. But I mean, this has been quite refreshing to hear a lot of this, because then that means more people can access. The issue of goodwill that needs to be paid, and it's in some cases it's a gentleman's understanding. It's not really written down. Is it legal?
Yes, goodwill is legal. It's recognized under the Act.
Yes.
And actually, when you are getting into a premises, you can agree with the landlord that I'm paying a goodwill of 2 million. When I'm leaving, you allow me to recover it from the tenant who will be coming in, or you refer it to me, and then get another set of goodwill from the incoming tenant.
Yes.
It is recognized under the Act.
Okay.
Yes.
All right. I mean, this is great. And I think it's one of the times where we've had this conversation, and then there's so many things that we didn't know, and that folks can now start to pick up on this. And I guess that's all part of accessing justice. So we want to thank you so much for being here with us this morning on Justice Thursday. The Honourable Ndegwa Wahome is a member of the Premises Rent Tribunal, and he's been with us on our Justice Thursday conversation on enhancing access to justice through this tribunal. Thank you so much for doing that with us this morning. Again, like I said, it's just great to be able to hear that there's information out there that we can actually consume and use. Thank you very, very much.
Thank you. I'm happy to have been here.
Our conversations continue after this. Good morning. It is 8 o'clock.